stage. Can everybody hear me on the? Everybody should be able to hear me. Okay, cool. I was on mute intentionally. All right, so for those of y'all who do not know me, and I think I know most of y'all at this point, I'm Nick. I'm the attorney with Knipp Law Office. Very close up, which I don't love, but it's okay. We are working on basically today talking about estates and more importantly for you, how to sell and buy out of an estate. So I'm going to share a PowerPoint that I've put together. Basically, just talk about how the easiest way you can deal with it. There's sometimes isn't an easy way, and just the different circumstances you run across when you are dealing with an estate. If anybody has any questions during the course of the presentation, that's why I'm here. Let me know. I want to answer. I want everybody to walk out at least feeling like you know a little more than you knew than when we started. So we can go ahead and I'm going to share my screen and get my PowerPoint up here. All right, so everybody should now be able to see the PowerPoint on the screen. And so basically we're talking about kind of the intersection again of real estate and probate and how this can help you learn, how this can help you more quickly facilitate a sale. Is that? That's how it's working. Yeah, let me share better. Let's try this. How's that look? Is that better? Is that worse? Huh. It shouldn't look like that. Oh, good. Zoom quit unexpectedly. Generate reports. What in the world? So I like to listen first. Okay. For some reason, my Zoom just died on me, but we're back. Sorry about that. Although it wasn't my fault. Okay. Let's see if I share this. How does that look on the screen? Perfect. All right, cool. All right, good deal. So I've got what I want on my so good. So what we will do is I'm going to go ahead and move on to my first slide. And basically what I always do before I start these, I just go through some definitions of things you're going to hear me talk about during the course of the presentation. So you kind of know what they are. That's important. So first off, the decedent, you're going to hear me use that term. Not everyone uses that term. It's just the person who died. So if you're decedent, that's what it is. Last will and testament. What this is it's a document left by a person who has died that expresses their final wishes for the disposition of their assets. Basically, it's a list of instructions. So when I die, this is what I want you to do with my stuff. Probate, that's the annoying, I didn't put annoying, but it is annoying process of following the will's instructions or following the law of North Carolina's instructions and distributing the assets left by that decedent to their heirs and their creditors. Intestate is somebody who has died without leaving a will or without having a will that the decedent selects in their will. It's also known as an executor. If you have a will, it's an administrator person who you hire to guide you through. But I understand is the branch of the court system that oversees a few little. So the overview of the probate process is, I keep freezing. It says my internet's unstable. That's just, I don't know why my internet's not doing great, but it is what it is. So basically, the overview of the probate process. Had the funeral. After that, what happens? In an ideal world, they determine a personal representative, and so that's determined, that's appointed by the court. After that, the personal representative files a notice to creditors in the public newspaper. That's about a month out. Then the personal representative has 3 months to inventory all of the property in the estate. The personal representative evaluates any claims that have been brought into the estate and determines which claims are valid, which claims they disagree with. The personal representative then pays all their debts, files final tax returns, gift tax returns, anything like that. And then the personal representative distributes all the remaining assets to the people in the will. And then they file a final accounting and the estate gets closed. The whole process, again, in an ideal world, 6 to 8 months is about what I say, but I mean, it can go later, it can go longer, because generally speaking, the probate process is not ideal. So that's easy, right? No. And why is that? A lot of different people, because people don't always get along. So siblings can fight and not really see eye to eye. Stepchildren, step-parents don't always see eye to eye. The decedent and their creditors don't always see eye to eye, and just people in general don't always see eye to eye. People always complicating such a great process that the court has laid out and established for us. So it's too bad, but if people got along, this process would still be awful. All right, so what questions do you want to ask your client when you meet with them after they're like, okay, I get a phone call, hey, my mom died, my dad died, my aunt died, my uncle died, I'm the executor, I want to sell their property. It's interesting because there are times where you get a phone call 1 to 2 days after someone dies, hey, I'm ready to sell this house. And there are other times where people use the time to process. And again, people just process it differently. You got some people that part of their processing is, I want to get this past me, I want to get this over with, and that's part of this. You also have some people that take their time to grieve, take their time to see it out. There's no right or wrong way to do it. It's just how people process and process them. So the first question I always tell folks, how are you doing? How is your family doing? Because jump in, you start talking business. Some people are probably going to be turned off by it. Some people are, but if you ask that question, that at least opens the door to somebody to like, yeah, not many people have asked me that. And so you can be the caring, kind realtor that they've always been looking for. Now, the second question I always say, did you find a will? Did they have a will? Do you know if there's supposed to be a will? Some people will know. Some people will have absolutely no clue. And some people will know their parents didn't have a will, or the decedent didn't have a will. So if they have a will, that's great. That kind of points out, okay, we know who the executor is. We know how this process is going to work out. If there wasn't a will, so I got a question on the chat. What is a legal will in North Carolina? So there are a bunch of kinds of legal wills in North Carolina. So the standard for a will in North Carolina is take one to an attorney, have us draw it up. It has to be witnessed by 2 people. That's what's called a self-proving will. And so that basically says that 2 independent people who are not related to the decedent or to the testator, that's the term, have witnessed the will, and it's been notarized, so it's a legitimate, hey, that we know that this is something that we're not going to have to do any additional investigation into. That's your will in North Carolina. North Carolina also you can do what's called a holographic will. And what that is just you're writing on a piece of paper, this is who I want to have my stuff. Sometimes that can work, sometimes it can't, because there has to be substantial evidence. decedent is actually their writing, is actually their desires. Because I mean, there are circumstances where you've got someone who wants to come in and say, hey, yeah, this is exactly what they wanted. Could have been just the first person to get there. Writes on a piece of paper, completely different handwriting, completely different desires. Oh yeah, Johnny gets everything. Nobody else gets anything. Well, there's going to be some questions that are going to be raised if Johnny just happened to be the first person to find it. So realistically, a legal holographic will, if you come across that, there is going to be a question as to whether that's going to be accepted by the court. And generally, you see something like that, it could give rise to estate litigation, stuff like that. You don't want to run into that. If you run into a situation where someone's trying to push a holographic will on you, I would refer them to an estate attorney like that. And I would not list that property at that point, because that's going to lead you down a path where you're going to get something under contract and there's going to be some will contests, there's going to be a bunch of fighting, and you're not going to have that transaction resolved for safety. So that's my suggestion. I hope that answered your question, Ken. In terms, so the number 3, make sure that they've retained or connected with a probate attorney. Ask them if they have. If they haven't, I mean, that's okay. People go through the estate process by themselves all the time. They're just not super efficient at doing it. It's going to take longer for somebody who doesn't have the experience of going through that process. If anyone ever asks me, hey, should I get an attorney? Absolutely, yes. That's my quick answer. Yes, always, because they know how to do it, and you generally don't. And it's not me trying to be rude or off-putting. I'm sure that every person who thinks they can do it themselves is a very smart, capable person, but it's just there are little nuances of that process that some folks know and other folks don't. Number 4, is the estate open? Sometimes the estate has already been open, whether they have a probate attorney or not. If it's within 2 years and you have an open estate, then that's great. You're already on the way to selling the property. If it's been 2 years and there's no estate open, you have to open an estate. If you want to sell your house, got to open an estate. You got to run a notice to creditors. That just is what it is. Number 5, do you expect that there are going to be any heirs or spouses of heirs who are going to be a problem? That's a good question to ask. I just got in touch. I just handled a file for somebody, or initiated a file for somebody, asked them to write up a contract, and I got the contract written for him, and I get a call, hey, so-and-so, I've got an aunt who really she says she wants more money than everyone else because she gave more help to everyone else and no one else agrees with her. So we can't buy the property. So it's stuff like that, little things like that. Again, not everyone's going to get along. So you want to make sure that if you're going to list a property like that, you're going to know, number 1, whether you have problem areas. Number 2, where those problem areas, where that little massaging of feelings is going to need to take place. And then number 6, do you have any heirs who have already passed, leaving any minors to inherit? Minors who are entitled to property usually can be a big pain because they can't sign the contract. So they would need somebody they can't sign the deed. So they would need to have somebody appointed on their behalf, generally by the court, which is going to extend that period. So let's say you've got somebody who's got 4 children and four siblings, but one of those siblings has passed away. They've got a 13-year-old and a 15-year-old child who they left behind. That 13-year-old and 15-year-old would be the 2 to inherit from them. However, they wouldn't have the contractual ability to sign, so they would need a guardian appointed to go through that process, which again can take a while for the court to resolve. All right. Any questions about this slide? Cool. So moving on to the next one. How did I end up with this estate? These are the different kind of ways that you end up with an estate process that you're selling out of. Number 1, you got a will that directs the property to be sold. We like that. That's easy. I wish more attorneys would draft wills like that, but they don't. Number two, the property ends up distributed, who all need to sign. You all should be involved in something to be sold in order to pay creditors' claims. So the person who died owed a lot of money. And even though one of the children wants to probably keep the property, there's not enough liquidity in the estate in order to pay off all the claims. A lot of times this comes about with a Medicaid lien or something like that, where they've been in a long-term care situation, something like that. They owe $150,000. They don't have the assets to pay that, but Medicaid will put a lien on the home, on the estate, because they know that they've got a home that can be sold. They can pay those assets. So you'll end up with that there. Number four, a lot of times you knew the decedent and their family trusted, so they wanted to make sure that they had someone who they knew would guide them through the process. Because again, selling your home through this process is not super easy. And number five, the seller dies while under contract, and people get super freaked out when this happens, but it's not as bad as it seems, and we'll talk about that here in a bit. Which understandable. All right, so the first one, the will directs the property to be sold. To me, this is the easiest of the estate seller situations. Basically, in the will, it'll just say, okay, the property is to be left to the estate. The estate is to sell the property and distribute the proceeds amongst my heirs. That's easy, because the only person that needs to be involved in that situation is the executor. The heirs do not need to be involved in selling the property because they don't have any ownership interest in the property up until the property is sold and is turned into money. And so the only person that sells it is the executor. They're the ones whose judgment matters. The heirs can complain and whine and cry all they want about who should sell this property for more. Nope, it's the executor's decision. So they sell the property for what they need to, by what they determine its value is. And how does that happen? Open the estate. Creditor's notice runs at least once. If it doesn't run, then the sale is void as to any creditors, meaning that, let's say that Medicaid liens out there owed $150,000. You try to sell the property without opening an estate, somehow are able to do it. Medicaid can say, nope, 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 nope. We're going to wind this sale back, and the sale is void. And so then Medicaid can reopen an estate or open an estate itself, sell the property, collect their money, and that's a real problem for you as it could be a real problem for you as a realtor. Really, that would be a huge mistake on the attorney's part too. We wouldn't make that mistake. And who signs? Again, the seller of the property is the estate, so that's just the personal representative. The second one, and this is the one we generally see, is that the heirs own the property. So the property is left by the will, and it goes, I leave the property to child one, child two, child three. So you got three children, they're all involved. So they all need to sign. Also, the executor, if the estate was open within the first 2 years, or if they're trying to sell the property within the first 2 years, have to open an estate. There's no way around it. So and the theory behind that is that during the first 2 years, any creditors would know, okay, this person has passed away. If you're owed money on a credit card, or Medicaid would certainly know if somebody passes. So they've got 2 years to really, because if someone doesn't open an estate themselves, any creditor that's owed money can open what's called an affidavit of collection, and they can open an estate. They can force a sale of the property, and they can then collect that way as well. So that's why it's required. So the theory is, over the first 2 years, you're owed money, you'll get it out of the estate if you can. And if you can't, and sometimes they can't because the person doesn't have any assets, but sometimes but if it doesn't happen after the first 2 years, then at that point, you don't have to open an estate. So if you're talking to somebody and they've just their families decided to sit on the house for 3, 4, 5 years because they didn't want an open estate, they didn't need to sell the property, but finally someone's decided, you know what, we're not doing anything with it. We're paying taxes on it. We don't want to deal with it anymore. You can sell it without opening an estate. All you have to do, well, all I say is you can sell with using what's called heirship affidavits, meaning that you would have to find two people that are completely unrelated and not going to gain from the sale of the property. And those two people would have to say, okay, these are the people who, this is the people who, these are the people who are the heirs. And I know, and I'm signing a notarized affidavit that these were the heirs that didn't have any other people who would be entitled to the property. And so these are the people who need to sign. And generally, title insurance company is going to accept that as sufficient evidence that those are the people who need to sign. Like I said, so the estate signs off on this as well, if there is an estate that's open. And the reason the estate signs off is because the property is being liquidated. And so this is the estate saying, okay, I'm releasing the property from any sort of liability towards the estate because now I'm getting money out. And so if there's money coming out of it, the money really should be entitled to go to the heirs, because the estate is saying, I have sufficient assets in the estate to be able to satisfy any claims that may come, or there have been no claims that have come. You don't expect any claims. So then what happens is they then sign an open estate affidavit, all parties, to say that if there do happen to be any claims, then the house is out of it, and I, as the executor, and we as the heirs understand that we're responsible for those claims. So that's how that process works. That's kind of why it goes like that. In this situation, if I'm a listing agent, I'm not just having the executor sign this contract. I'm having every single heir sign the contract, because the heirs are the ones that own the property here, not the executor. Spouses of heirs also need to sign because of that pesky marital interest that North Carolina has. Spouses of heirs also need to be involved here. So Margie asked me a question, do heir spouses need to also sign? I always suggest yes. And the reason I suggest yes is because that sets the expectation to the spouse that they also need to be involved in closing. I've seen situations before where we've had spouses who have completely refused to come in, completely refused to sign anything. Well, I'm not involved in this. I didn't inherit this. I don't want to be involved at all. Well, you're married to someone and they are involved. So thanks to the state of North Carolina's laws, you are also involved. You might not want to be involved, but you are. So it's just a good way to set expectations up front. Do I think it's legally required? I don't. But do I think it is a very good idea because it sets expectations and also binds that spouse to say, hey, you signed a contract. Now, if you refuse to follow through on that contract, then the sellers can then, or the buyers can then come back and sue you for either damages, or they can sue you for specific performance because you were supposed to do something that you didn't do. And because if you're listing the property, you're listing the property with the intent to sell it. You're not trying to protect any of these spouses or anything like that. That's not your job. Your job is to get this property sold if you're going to list it. So, in my opinion, you should have everybody, heirs plus spouses, sign. If you don't have spouses sign, I would make darn sure that your clients know that their spouses need to sign, and make sure before you list it that you've got their sign off that, yeah, they're going to come in and sign. It would make sense to even speak to them and give them that indication. Just know that you're going to have to be involved in this process. Because if they don't and they refuse, then that puts everybody in a bad spot. Any other questions about this slide? All right. So the next one, sometimes you run into feuding siblings, and that's a lot of fun. So a lot of times you have a situation where you got one sibling that says, well, I want to honor my family's legacy. I don't want this to go outside of the family. I want to keep this. I want to keep this property. Then you've got another sibling that says, forget that. I want the money. I want to get money out of this. And the sibling who wants to honor the family doesn't have the assets to buy the other sibling out. So you've got one sibling who's willing to sign, another sibling who's not willing to sign. That happens, then once the sibling who wants the money can file something called a petition to partition. What that is a special proceeding that is opened by the court, and that special proceeding is basically open saying, okay, the court's saying we can either, and the partition thing is funny, because if it's land, then the court could actually say, you know what, you can hire a surveyor and split that land. You keep that part, you get this part, and you each do what you want to with it. But most times, it's not land that's involved, it's a house. And when a house is involved, kind of hard to split a house down the middle and say, you get this part of it, you get this part of it. So the court will then force this property to be sold, and each gets half, and that's just kind of the way it goes. And so if you get into this situation, then what you're probably doing is you're doing a lot of mediating, you're doing a lot of massaging of the feelings. You're just trying to be kind of that person who's like, hey, you know, I'm just trying to move this down the road. Now, if you get here before this petition to partition is in place, you're probably in for a real fun time. And again, that's part of kind of that initial analysis that you want to do. Hey, you've got a spouse who doesn't want to sell this property, or no spouse, you've got a sibling who doesn't want to sell this property. Do you really want to be involved in a, because this is also a separate court action that needs to happen during the estate process. Do you want to be involved in a 6 to 8 month battle between siblings? If it's worth it to you, then yes. But I mean, again, this is something you might want to have worked out or already in place. But this is also something where if you get to this point, you've listed the property, you're under contract, and then you find that one sibling is really against this, then you can feel free to reach out to me. This is what I will suggest. And I've got some good attorneys that I can refer you to who I've done in the past. I know I did this for one lantern agent in the past who they did a great job. And then what'll happen, another thing you'll want to let the sibling know, hey, what happens is the court appoints a commissioner to sell the property. That commissioner can get up to 5% of the sales price. So not only are you paying a list agent, not only are you paying a buyer's agent, now you're also paying a commissioner who's generally an attorney who's going to come in and sell the property too. Not only are you paying the commissioner, you're also paying an attorney that you hire who may or may not also be the commissioner. So real quick, that money starts going all sorts of places. So the more you fight, the more money you're going to spend. And that generally becomes pretty compelling. Any questions on this? All right. So next one, paying off debts using the house. This is that Medicaid lien.
Real quick, I got a question. Sorry, I couldn't.
This one can also require a special proceeding along with an estate file. So that's potentially 2 court actions in one. Now, a lot of times, somebody may have more debt than they're able to pay off with personal property and bank accounts. So, like I said, Medicaid. So how do you do that? Again, it's another special proceeding, another file for the court, more money for somebody. And this can be done in the name of the heirs. So the heirs can say, you know what, you've got to bring the house outside of the estate because this is where the house is left to the heirs, but they have to bring the house from outside the estate to inside the estate. And then at that point, then it's sold by the executor. And the executor says, okay, I pay this off. After I pay this off, everybody else gets the rest of the money. Again, if you're going to do something like this, it's really important to suggest, I'm not going to work with you unless you hire an estate attorney. I'm not going to let you do this yourself. You have no idea what you're doing. And we're going to be sitting here in 12 months in the exact same situation we are now because you decided you could do this yourself. You didn't want to hire it. I would really suggest if they're not working with an attorney, that you really should, you might want to consider stepping away if you want your commission any sort of reasonable time. Ashley asks, so if they Medicaid and didn't plan on selling, can Medicaid force the sale? They can. Medicaid can jump in and say, you know what? You're not going to open an estate, but we're owed money. We're going to force an estate. We're going to request that the court open an estate, that the court appoint an attorney to administer the estate and sell it. That way Medicaid can get paid. So the court Medicaid can force it, and they can open and force the sale. And then Nikki asks if they're feuding siblings, and it says in the will that they each get property A and B. But one sibling says they want both properties or a piece of A's property, even though the will says they get B's property. So if they can agree, then if the feuding siblings can agree, basically the court's going to enforce the will. So if the will says you get this, and then one sibling say, no, I want this instead, the court's generally going to honor the final wishes of the decedent. They're not going to say, well, even though you said you get this, even though the decedent said you get 1, 2, 3 Main Street, but you want 4, 5, 6 B Street. Well, they're going to say, no, the person who left you the property left you 1, 2, 3 Main Street. If they took the time and had the consideration to specifically leave that to you, then that's what you get. So they're generally not going to overturn the wishes of the decedent. Both parties would have to agree generally in order to force any sort of sale or anything. So Catherine's asking, can anyone challenge a will if they're not receiving anything in the will, such as ex-siblings not listed as an heir? They can. Yeah. If you've got somebody who is left out of the will, they can file what's called a will contest. Now, generally, will contests are only successful if somebody can prove that, let's say, there's some undue influence that's been taken against them or something like that. Like, I've seen successful will contest actions where you've got one sibling who's been very attentive, who's cared a lot for the decedent, has seen them through kind of their last days, but magically a month prior to their dying, they went out and took out a completely new estate plan, disinheriting one child and naming the other child as the only one to get anything. I've seen a successful will contest where it says that there's some undue influence, or that somebody used a power of attorney to sign a new will or something like that. You can't do that. But I've seen attorneys prepare this. It's crazy what people do. Excuse me. So I've seen it happen before where you can see a successful will contest where it's clear that undue influence took place. And what'll happen is, if that happens, that will gets thrown out, and the court will essentially determine, nope, you get this, you get this. Now, I've also seen unsuccessful will contests where one sibling was out of state, paid no mind, gave no care. The other one moved into the home with the decedent and cared for them and lived with them and made sure that they're okay. And I've seen those be unsuccessful will contests. So it really just comes down to the specific circumstances, the health of the decedent, what the mental capacity of the decedent, things like that when they pass. Any other questions about this slide? All right. So moving forward, got this situation. I've dealt with like 3 of these in the past 3 months. It's been wild. These are actually not so bad. It's bad because obviously you've got a seller who went under contract and then passed away. But I mean, that's terrible for them and their family, obviously. The process is not that bad to do. So what do? Obviously, it's a very unique situation. You don't see it much, even though I've seen it a lot recently. Actually, a little easier than your normal estate selling a property out of an estate proceeding. All you have to do is open the estate. Once you open the estate, then whoever's appointed as the administrator, executor, personal representative, they just need to carry out the final wishes of the seller who was under contract and complete the contract. You don't have to run anything in the newspaper. You don't have to do anything in terms of notifying anybody. You don't have to have any heirs involved. It's just the executor carries out the final wishes. They can sign the deed. All the proceeds in that one go to the estate. Nothing goes to heirs, anything like that. Why is that? Because the contract was put in place while the decedent was alive. So all you're doing is carrying out their final wishes. There's no interpretation, anything like that. You knew exactly what they were selling the house for. That the personal representative isn't making any decisions. They're just carrying through what the decedent had. The only challenge here is if there is no will and you've got multiple siblings who are each of them want to take that process, it's again, let us know. We can talk to them and say, hey, nobody's winning on this. I mean, ultimately, it's just who signs that last document. I did a closing last week, and there were two sisters sitting next to each other. The only difference between it was who was signing the document. So this one, like I said, it's not that it's stressful, obviously, but it's not stressful. All right, so here's my advice on what does this mean for a listing agent. Again, the name on the listing. I think it's always safest to name both the personal representative and the heirs on your contract. You can always amend the contract later if you have to add the estate or something like that. But you can also ask his attorney beforehand. I get questions about this all the time. I have no problem answering them. I just ask what the circumstances are. If you don't know what's on the will, which a lot of times as the list agent, you're not going to read the will. You end up, or a lot of times, you're going to have an unsophisticated seller who's read the will, who's grieving, who's struggling. They won't necessarily know what the will says either. They won't know the difference between, oh yeah, the seller or the decedent left the property to the estate for the heirs to sell. They're not going to know all that. Ideally, again, you're hooking them up with an attorney so they can do that evaluation for you. But I think it's safest to name everybody and then pull people off later if you need to. Number two, try to have regular contact if you can with the probate attorney. If you don't have one, we can provide referrals for one. Let me know. Know when to refer questions to the probate attorney. And again, don't practice law. It's not your job. No one expects that. So if you need referrals, we've got them. But don't start spouting off legal theories, everything like that. That's not why I'm teaching you this class. I'm just trying to give you some information that you can have so you can know what to expect about the process, and you can speak a little bit more intelligently on, okay, these are your time frames, things like that. Number three, try to connect your closing attorney and your probate attorney. Courts don't, if you're able to get some information from between the probate attorney to the closing attorney, that'll potentially save the closing attorney from having to do another title update down at the courthouse, because the probate attorney can send that information time to speed up titles. Also, get invoices out as early as you can. If you've got an estate-owned property, especially one of those that's been sitting 3, 4, 5 years, they require a lot of repairs. You can also see if you can pay probate attorneys' fees out of the estate. Some probate attorneys are good with that. Other probate attorneys, they're going to want to get paid up front. But I used to do that kind of work. I mean, you kind of know. A lot of times you get an initial retainer and then understand that you're going to get the rest of your payment once the estate is settled, because that's just kind of how you get paid. You get paid by the estate, not necessarily by the heirs direct. It's doable. Now, what does this mean for a selling agent? I've got a theme here. So, patience. Sometimes you have to track down heirs. Sometimes it's a pain, especially if you've got multiple generations to be dealt with. We've had estate sales that have had 30, 40, 50 sellers. It is a pain. I went down to the courthouse one time and they asked me if I would be willing to handle a file with 106 sellers. I said no because I have other things that I got to do with my time. I do feel bad for whoever got appointed that, but I mean, there are some estates out there that are absolutely nightmares. Be patient. Title search sometimes has to go through multiple counties. So if somebody passed in Rowan County, they've got property in Cabarrus County, you got to do both. Sometimes probate happens. Sometimes people died out of state. In that case, you have to do what's called an ancillary administration and administer another estate in North Carolina, even though there's another estate opened in Tennessee. Be patient. Heirs can be reluctant to sign. They can fight. Again, as a selling agent, you're not really part of all that. That's the listing agent side. So you're kind of just waiting on that process to bear out. I've got one going on right now with a lantern agent where we've had disagreeable heirs, and because of those disagreeable heirs, the process is extended way further than it should. Number 4, be patient. Sometimes, again, estate process property's only been passed on by inheritance, not deed. So in that case, you're pulling out family trees and trying to figure out who Uncle Cletus's 5 kids were. It's a real pain, but sometimes you got to do it. It requires reviews of numerous estates, which again can be in numerous different counties or states. And number 5, be patient. We want to get this closed just as quickly as you do. We don't get paid until this closes either. So it does us no benefit to sit on a file for months and months and months. But sometimes that's just that's the circumstances dictate that. So it's okay. All right, I've got a question on the chat. So let's say an aunt dies. In her will, it says her sister gets the house, sells a mortgage. Nephew's been living with the aunt. This seems specific. The nephew squats in the property. Can the sister kick him out quickly since in the will it was left to her? There's never a lease signed with the nephew. Does the nephew have rights? Squatter laws is for a customer in New York. I cannot speak as to New York law. I'm assuming the customers in New York, the laws, the client is here. I've done this before. You'd have to file for a petition for custody and control of the property as the executor of the will. Then you've got the authority to boot somebody. I've done that before as an executor of the property. Property is the aunt's. If it was left to the aunt's, if it was left to the aunt, that's whose property it is. So they can file for an eviction in order to do that. Squatter laws are not really that strong. North Carolina doesn't really have strong squatters' rights laws, which is good because I don't like squatters. Neither should you. So they just need to go through the eviction process to get them out. But the court may say that they have to file for custody control, and a victim is the executor as well. If there's an estate open, if there's no estate open, then if there's no estate open, then the property's not hers yet. Because if the will is what dictated that she got the property, then you have to probate the will in order for the estate to go through the process. Remember, a will is just a set of instructions, but it has not been put in force until the will is probated. So if you don't probate the will, then what the will says doesn't matter. You have to probate with the court, even past the 2 years, in order to have it be enforced. All right. So here's your red flags. These are the things you don't want to do. Number 1, if somebody says, oh yeah, let me sign on behalf of the person who passed. I've got a power of attorney. Do not do it. Power of attorney does not have an effect after someone dies. The power of attorney dies with the person. So they have a power. They say, oh yeah, I can sign them for it. I have a power of attorney. Doesn't matter. You're not the executor. You can't sign for them once they pass. Don't try to act as a quote unquote expert out of selling an estate, because every single estate situation is completely different. You can give kind of overall guidelines of, oh yeah, I've sold out of this estate before, I've sold out of this estate before. But really, if you have any questions, please ask me, or please ask an attorney. Please get them over to a probate attorney. Do not try to act as a substitute for a probate attorney, because you're not. And I'm not trying to be offensive there. I'm just trying to keep you out of real estate too. Number 3, don't leave the attorney to guess how proceeds are going to be split. Sometimes there are going to be proceed splits that are not 50-50. If you have a proceed split that is not 50-50, number 1, ask the heirs that question before you get here, because I have had a fight over proceeds at the closing table. It's not fun. I would very, very much ask you to not do that to me. I can handle it. I'm a big boy, but I really don't want to do that. Because not only does that reflect poorly on the clients, that also reflects poorly on the agent. Because anytime there's a fight at the closing table and it's over money, it's just because you generally hear that the agent was very hands off throughout the whole process. You got to be somewhat hands off. That's just part. And then one last thing, I always do a bonus here. So what happens if my seller is incompetent? Because sometimes you'll have a situation where you've got a seller who is truly incompetent and is no longer capable of signing on for themselves. If you have a power of attorney, that's when you can use your power of attorney. That's why it exists, to have somebody take action on behalf of your incompetent seller. However, if you don't have a power of attorney, the incompetent seller is going to have to go through the process of establishing a guardianship. And that's not fun, because that's a long process involving doctors. It's involving somebody who might not feel they're incompetent. And so they're going to be stressed out. And this can take several months to get from step A to step B. So if you list a property with people that you are confident when they get to the closing table. And if they're not confident when they get to the closing table, me as a notary, I value that. Me as an attorney, I value those licenses. So I'm not going to just say, well, they wanted to sell it. I mean, it's really difficult. So if you can see that that's going to happen, consider having them get a power of attorney, especially if you notice they're generally knowledgeable about what's going on, but they forget things here or there. You never know how quickly that can decline. So ask them for their power of attorney. If they don't have a power of attorney, you might want to suggest one. They might not be happy about that, but talk to their spouse and let them know, or talk to their spouse, their children, whoever could serve. Let them know the potential pitfalls that could happen if they were to be incompetent between that process. So, and then I've got a couple of questions here on the chat. Give me 1 second. Get to them. Whoops. So Ashley asked, if the home's placed in a trust, does it still have to go through probate? No, it does not. Because a trust survives probate. So if your client has a trust, your trust is going to survive probate. A trust is a great idea. Our firm has an estate planning department that can establish a trust for your clients if they have any interest in doing that. So if the home is in a trust, then I would say then makes life a lot easier. Doesn't have to go through probate. Whoever the successor trustee is on the trust has the ability to sign and sell on behalf of the trust. And Jessica, I'm happy to provide a copy of the PowerPoint. I'll send that to Melissa and have her distribute that to you. All right. Any other questions that anybody has about what we've gone through today? I know it's a lot of information. I'm happy to answer any questions that anybody has. I know selling out of an estate can be stressful, so please let me know. Amy asked, can a property go straight into a trust at closing? Yes, it can, especially if you're doing a cash transaction. You can sell straight into a trust. The way the contract reads now, even if you go under contract as an individual, one of the entities on the deed can be sent to, I think it's paragraph 10 of the contract. Or page 10 of the contract, sorry. You can actually go under contract as an individual, establish a trust during the course or during the term of the contract, and then that contract can go into the trust without even having to amend the contract. You just need to let the closing attorney know. If you're getting a loan, it's a little more difficult to put a contract straight into the trust at closing. What I usually set, but a lot of folks, what they'll do is they'll get a loan in their individual names, and then they will move the property into their trust after closing. Generally speaking, the lender's not going to care as long as that mortgage keeps getting paid. And a lot of times, I don't even think it's a violation because the beneficiary of the trust, especially if it's a living trust, is going to be the same people who are on the deed of trust. So they've still got ownership. Any other questions or anything like that? Cool. I think we're good. I tried to keep it to an hour, so I think I successfully did that, especially with my technological issues. So, like I said, if anybody has any questions, let me know. That's why I'm here. Happy to help. I appreciate everybody who was here both in person and on Zoom. And yeah, anything you need, I'm here for you. So y'all have a great rest of your day. Thank you for everybody who joined. Y'all take care.